Here's some choices. To do 3 of these would be very, very long, and so I'm going to do one of these 3 things, and I'd like to know which one you would most like to see. First is the first lie that I noticed. This is about Aggravated, about my brother's case, yeah. And how hard it was to discover the truth about something as simple as an athletic event. Okay? Number 2 is we had some proof of jury misconduct that was given in the court. The proof was given in court, but it was useless. And I'll cover that if you like. And then the third thing is how a 2001 newspaper article coupled with a bunch of Information Act requests may get my brother a new trial. So, the first one, anybody want to see that? 2, 3, 4.
Yeah.
Okay, second one? Not too many, no. The last one?
I think we want
Okay.
the first one.
Number 1, okay. I have to do this way. To jump to that instead of the others. Okay, this is the first example. A cross-country race is what we're talking about. And I call it the first lie because it was the first one that I noticed that I thought I might have a chance to prove. Okay. And so how did I notice the lie? In the trial number 2, there were 2 trials. My brother first trial was a mistrial. They couldn't make a decision. In the second trial, they made a decision, but I'll tell you about that later, but in a weird way. And he was convicted on 1 count instead of 3 because of a deal he made. We'll get to that later if you want to hear about it. But about 10 minutes into Hanna's testimony, that's not her real name, and Mr. Blunt is not his real name, asked her about her abuse. How do you know you were 12 when it started? And she said, well, I went to this race in Langford. Doesn't say that. Yeah, first meet was in Langford. I ran a mile. I was really young. I was the youngest person there, but I ran against 300 and some odd girls. I came in 16th place. I was very proud of myself, and I'll never forget it. And he asked her some other questions, and then the other important part is, he says, well, how did you remember that specific date, that it was September 8th? And she said, it's also a very good friend of mine's birthday. When I did finally read this passage, that was all I knew, was that right there. I didn't, that was the last thing actually that she said on record to anybody, but it was the first thing I read. But I didn't find it out right away. The trial took place in 2006. It was late in 2007 when I actually first got transcripts from trial number 2, which took place in August 2006. But I didn't read this piece of information then because I only got the last 2/3 of the trial transcripts, not the first third, which was when the voir dire and when her testimony was about this particular thing. I read other stuff first. I helped him work on his case for a couple of years, just trying to help him mostly with grammar and with other things. I don't have a legal mind, so I didn't know what I was writing some of the times, but was be able to correct his spelling and stuff. And around 2010, I got the rest of the trial transcripts, and that's when I was able to read it. So this is 4 years after he's been incarcerated, before I got a chance to actually read that part right there. I continued to work on books all this time. I was writing and helping him when I could. Within the next 3 years, but mostly early in 2013, I got transcripts of trial number 1. So at that point, I could compare trial number 1 to trial number 2. And I got an audio interview with the girl, which was 2.5 hours long and covered all kinds of things, including this race. So at that point, I was able to compare that as well, although it took me forever to transcribe it because it was really crappy audio. It was horrible. In 2016 and 2017, once I was already writing Aggravated, I filed a bunch of TPI requests, and one of those gave me a May 2004 summary from her counselor which mentioned the cross-country event. So the order in which I read them was that trial number 2 first, and then trial number 1, and then the interview, and then her counselor's summary, which was completely backwards chronologically. But I could look at all 4 of them at that point and see there were changes from one to the other. The one thing she was consistent about was that it was on September 8th. It was a mile. She ran against 300 other girls, and that she came in 16th place out of the 300. So I was able to compare the versions and see what I saw, which was that that didn't change, but some other elements did. And in order to investigate it, she said the race took place in Langford, Texas. This is how I went about it. I called a bunch of the schools there in Langford, and every one of them said, no, we couldn't have done that possibly because we're all AAA schools, and her school, Alderson, was an A district school. You have that here in North Carolina, where A is small and AA is bigger. Yeah. So the name of the place that she said it was not correct. I interviewed Hanna's principal. I went to the school and I talked to the principal and the counselor. Gave me a lot of information about her and about the time period and other things that happened with her, but they seemed really puzzled about this race.
How willing were they to talk to you about this?
Very.
Really?
I walked in, I said, I'm writing a book. It's about a trial that happened. A student of yours at the time was involved.
Did they know the connection?
Very upfront, you know.
Did they know the connection?
They knew her right away.
What about you and your brother?
Your connection.
Yeah, your connection.
To your brother, to the...
Probably didn't say that the first time I got there. I may have said it toward the end of the interview.
Okay.
I think so. At some point they did know.
Mm-hmm.
Well, does your brother have the same last name?
Oh, yeah.
So they might have figured it out. Anyway.
Interesting.
Yeah.
That
Well,
kinda
actually, he
surprises me.
pronounces his name Soroy, and I pronounce my name Sirwa.
Okay.
I started in 1970 when I moved to Houston because I was going to be
In
acting,
Texas.
and people had always mispronounced my name. Cirrhosis, psoriasis, you know.
Yeah.
And
Serious.
and serious, yeah, I got that a lot.
Serious.
So I figured, you know, I ought to try the French pronunciation and see if they could get that, and they didn't really. They said they had no records of any events from 2001, any of their athletic events, which I found odd, but then every school I talked to told me the same thing, that they just didn't keep records, which I thought that's part of what school was about. But
It's on your permanent record unless it's in sports.
I contacted runners organizations. They said they didn't track junior high races. I asked who might, you know, other than the schools, and they didn't know of anybody other than the schools who might keep it, you know.
You think the yearbooks would have some of that stuff?
Oh, good.
Or a
point.
student
That-
newspaper.
Okay.
I haven't got to that yet. But
Don't jump the gun.
I didn't find out anything about the race itself, but I did another trip back to her school. I talked to them, and I said I was trying to find out what events she was in, and they took me to a room in the library where they kept all their yearbooks, and somebody went through them with me and showed me what team she was on, and just step by step, all 4 years, which answered a lot of other questions, but yeah. I kept contacting schools in the area, and they all said that they didn't keep records for more than a few years. I did internet searches whenever I thought about it, and in 2015, on her school's homepage, there was a result from a cross-country meet that they had just done on September 8th. It's 2015, not 2001, in Myler, which is not a real town, but it's the town that's near Langford. So I searched for Myler and cross-country, and I found the 2015 result plus one from 2011. So I had two sets of information about races they had run, not the one she was in, but I could see how many people ran in various races, 30, 40, you know, not that many. I contacted Myler right away. They didn't keep past records either. They gave me the name of the cross-country coach in 2001 who was no longer there, but in the school he was at. It took me another year to get a reply from him. I sent him emails, phone calls, left voice messages over and over and over again. Every couple of months I'd try him again.
How big was the town?
Myler?
Yeah, of the real town.
The real town where they did the race?
Yeah, because those would be like on microfiche even for newspapers.
Yeah, 154 people.
Oh yeah, they
God.
definitely. That'd be a big
But
deal.
their school brought in students from.
Sure.
That would be a
surrounding
huge
area.
deal. That would
Yeah.
be like, you know, a whole section of the sports
Yeah.
section in the newspaper.
Yeah, It's something I could try.
Yeah.
But I finally got a reply from him. He said he didn't have any records from then either, and he couldn't remember, names of people who ran there, obviously. He said 300 people, no way. He said they might have at one time maybe combined a 7th and 8th grade group and maybe got 70 people, something like that. He said there's just no way that they ever had 300 people run in one single race. So, I now have a bunch of people, including the current coach in Myler, who's saying that he was there in 2001 and he remembers all of the races from then on, more or less, that there's no way, So I've been able to prove the lie. Has nothing to do with the trial.
Right.
There's no legal basis in it at all. But it's one thing that I'm using in the book to be able to set up the idea that from the very beginning she was lying. And then I was able to do the same thing with a lot of the other things that were actually in the trials, in testimony, sworn testimony.
Wow.
So nothing of that was useful in a legal sense, no, but it's good for the book.
Character. Establishes her
Yeah.
character.
Yeah.
I'm going to pause here for a bit so we can include the 2 examples that weren't used in the live presentation. But before we do that, let's do a quick summary of example 1. It took a lot of phone calls and emails and a lot of searching on the internet, but eventually I had enough data to conclusively call Hanna's story about the race a lie. And I've been able to do the same with nearly every other comment that she made on record. Unfortunately, it took a lot of effort and frustration in those cases as well. Even so, all the other lies, and there's lots of them, are going to add weight to Steve's assertion that, as he has always said, I didn't do this, it never happened. Even if we can prove these are lies, the statute of limitations on perjury is only 3 years in Texas, so neither Hanna nor her mother can be prosecuted for what they said in court in 2006. However, if Steve gets a new trial, we could ask them the same questions again, and, because of all the evidence we have now proving that they're not true, they would have a choice of telling the truth, which would absolve Steve, or facing possible perjury charges for lying again. Of course, to do that, Steve has to get a new trial, and the big question is, how can that happen now that his state and federal appeals are both exhausted? They might not be. Let's take a look at the other 2 examples. Here's example 2. It's titled Proof of Jury Misconduct, which was unusable. This is what got me interested in reading the trial transcripts. I first thought about it after Steve's motion for a new trial, which took place 2 months after he was convicted. A juror came forward after the trial was over, and she said they made a deal to convict Steve by trading votes. There were 3 charges against him, and the jury was deadlocked, like the previous one had been. This was his second trial. One of the jurors proposed that he would agree to acquit Steve on the 2 lesser charges if the other people who thought he was innocent would agree to convict him on the one more serious aggravated charge. At the motion for new trial, the prosecutor argued that the juror's testimony was inadmissible because the verdict had already been rendered. That sounded a little crazy to me, but the judge agreed, and Steve stayed convicted. So let's take a look at this jury misconduct and some other things that are related to it. The reason that Steve was convicted had nothing to do with his guilt or innocence. It all hinged on these 2 legal rules. Steve argued against both of these rules in his appeals, but every court all the way to the Supreme Court agreed with the judge and said that the guilty verdict would stand. 606B. Basically what this rule says is that if somebody wants to look into the validity of a verdict or an indictment, they can't have a juror testify about anything that happened in the jury room. They can't talk about how the jury felt, about any of the things that they talked about to come to a decision. There are a couple of things the juror can testify to, and one of them is whether any outside influence was brought to bear, like a threat or a bribe or anything like that. If somebody claimed that they weren't qualified to serve, they can testify to try to prove why they should have been able to serve. The other rule is a rule of appellate procedure. It's 21.3, and it says that a defendant has to be granted a new trial if any one of 8 reasons are met. There were 2 of them that I think apply to Steve in some regard. What it says is a defendant has to be granted a new trial if C, a verdict has been decided by lot, like drawing straws, or in any manner other than a fair expression of the juror's opinion. Trading votes falls into that very strongly. The other is when a jury has engaged in such misconduct that the defendant did not receive a fair and impartial trial. The jury was deadlocked, just like the first jury was. So they engaged in conduct that did not allow the fair and full expression of all of the jurors to be heard. So I think that both of those actually apply. However, because of 606B, 21.3c is nullified. All of the courts that Steve's appealed to said that these two rules aren't in conflict. One of them even said they work together to define jury misconduct and provide how you can prove it. I think that 606B prevents 21.3 from working. None of the courts agree with me, but how can you establish that there was misconduct if a juror can't testify that there was misconduct? I think that 606B prevents 21.3 from happening. In effect, what the rule says is simply that once a verdict has been rendered, what happens in the jury room stays in the jury room. Everybody's tried to convince me that this is a dead issue, that Rule 606B is never going to be changed. Of course, having jurors isolated from external influences is something that you want in a jury trial. You want them to be able to make up their mind. But shouldn't deliberate tampering with the jury's ability to make that decision on their own, to make that decision based absolutely just on the facts, be considered something that is worthy of taking another look at? Apparently it isn't. This issue's been appealed by multiple inmates to multiple courts many times, including to the Supreme Court. The court's rulings have always said something like, this is a settled matter, it's well grounded in common law. The Supreme Court recently, in a case called Pena-Rodriguez v. Colorado, raised the possibility that under certain circumstances, like racial bias, there could be an exception to the rule. Also, at the link that you see at the bottom of the screen, Washington, D.C. lawyer Andrew Hull explains that what they call the common law groundings, which makes it established law, might be an anomaly. He thinks that there isn't the support for the common law tradition that everybody claims there is. So maybe there's some hope that this rule will be changed. This won't apply to Steve, probably, because the law rarely changes to include former cases, but maybe for future defendants. Okay, let's look at example 3. It's titled, "An Accidental Discovery May Lead to a New Trial for Steve." I didn't expect this to happen. Usually there's a puzzle to solve, obviously, and this one just sort of solved itself in some respects. We're going to look at the voir dire of someone named Connie Wilcox, not her real name. She did become one of the jurors. During voir dire, by asking questions, the attorneys try to determine who in the pool of prospective jurors they most want to be on the jury eventually. The prosecutor read out a list of 10 names of potential witnesses. Hanna Templeton, Howard Childers, Jeannie Dixon, and David Connor were among them. Again, fake names. And asked if anyone in the jury pool knew who they were, or knew them, or knew of them. Connie Wilcox was sitting in the second slot on the front row on the left side. She raised her hand, she said, "David Connor," and said that she knew him because David dated her daughter when they were in high school. Other potential jurors also said they knew Mr. Connor, and they also said they knew many of the other people that the prosecutor had named, including Howard Childers and Jeannie Dixon. But after naming David Connor, Connie Wilcox didn't say anything else for the next 24 pages. By that time, the defense attorney was up. He asked if anyone there had never been in trouble with the law, not even had a traffic ticket. Miss Wilcox raised her hand, volunteered that she had never had a ticket or committed any crime. Later, the attorney asked, "Does anyone here work for or have a family member or close friend that works in any sort of position dealing with abused victims?" He clarified that. He said, "By that, I mean basically working in a shelter of some form, working as a counselor of some form, anything that would have special training dealing with the abused, possibly working as a CASA rep or a psychologist, anything along those lines." And then he, looking toward the prospective jurors, said, "Let's start on the first row on the left side. Anybody?" So he was looking right at Connie Wilcox. In fact, by that point, she was isolated. A couple of people on both sides of her had been eliminated already from the jury. She was sitting in her own little spot there on the front row. How do you suppose Connie Wilcox answered that question? She didn't. She didn't respond to it at all. Other people did. Other people answered and said, I have a friend, I have a neighbor, my son, my daughter, I did this for so many years. Lots of people answered that question, indicating that they knew somebody who worked with abused victims or worked for CASA or all of that stuff. She didn't say anything at all. As far as the attorneys knew, she had no association with CASA or any other organization that dealt with abused or neglected children, and she became a member of the jury. A newspaper article proved to be the solution to the puzzle. At some point, I knew I wanted to try to speak to the jurors. The investigator tried to talk to all of them as soon as the trial was over, but most of them didn't want to say anything to him, except for that one juror who said that the jurors had made a deal. I started trying to gather phone numbers at some point. Ultimately, I only found 5 out of the 12. But in searching for Connie Wilcox's number, I ran across a newspaper article. Here it is. It's in the Deep Springs Gazette, not the name of the real newspaper. It said child advocates sworn in. One of those people was Connie Wilcox. The article said that these 10 volunteers were sworn in as court-appointed special advocate CASA representatives. Justin Hawes was the judge who founded CASA in Deep Springs. Justin Hawes is a fake name, of course, and so there is no 555th District Court. He had tried for a long time to get it started, but a year before, in 2000, he found volunteers, and now they were swearing them in. They had had 30 hours of training in dealing with the abused and all kinds of things. At the bottom of the page, there was a list of the board of directors for CASA and the CASA advisory board members. Jeannie Dixon was on the board of directors. Howard Childers was on the advisory board. Remember those names? They were the names that the prosecutor had called out. There's a lot of surprising information in this one article. Connie Wilcox, the juror who hadn't revealed any association with Jeannie Dixon, who was Hanna's counselor. She was also an expert witness at the trial. Or with Howard Childers, who was the adult that Hanna first told she'd been abused. He was also an expert witness at the trial. Or with CASA, which is an organization that works with abused children. This person was named in an article 5 years before the trial as being sworn in as a child advocate by the very judge who presided over both of Steve's trials, and being sworn into an organization that had Dixon and Childers on its boards. We're not done. Remember Freedom of Information Act requests? Let's take a quick look at a TPIA request that I submitted to the Asheville County DA. This is just as a sample of sorts. You can use this as a model for your own. If you'll Google for requests from the state that you'd like to apply to, you'll find, I'm sure, several examples. I modified this from a request that was sent by someone else to a school district in Texas, and I used it as the basis for all the others I submitted later, and they were all successful in one respect or another. So, my TPIA requests. Between 2014 and early this year, I submitted requests to the City of Deep Springs, to Asheville County, to organizations like CASA and the Sheriff's Department, asking for specific information. If you have requests to organizations that aren't governmental or aren't funded by state or federal governments, they might be exempt from compliance, but trying never hurts. So what kind of information can you request? You can ask for anything. You might get it, you might not. Confidential information is usually exempted, but sometimes it's just redacted. This is a link to the Texas statute with all the details about what you can and can't do in requesting information. Same for the North Carolina statute. Again, Google your own state and ask for Freedom of Information requests, and you'll find several examples probably and information about how to do that in your state. So what did I get? I got some information about Steve that I think is going to be very useful for the book, and that's helpful for me as a writer. But also, getting back to Connie Wilcox, there's evidence that may get Steve a new trial. So what was that? Filing the Information Act requests was one of the most successful things that happened in the research for the book. I knew I always wanted to talk to the jurors if I could, but I assumed it would not be that important in the story. Proving Hanna's lies were the main thing that I was focusing on all along. But this information now I think is vital, and I think it's going to prove vital for getting a new trial. It's a trial we wouldn't have had a chance to obtain without this new evidence that I found because of these searches. So what happened with the requests? From the Asheville County DA's office, I was able to obtain about 200 pages of documents I didn't have before. I was able to actually go into their office, and they brought me a folder that they said had everything in it. It was only about 1,000 pages, which seemed a little skimpy to me. And I know there were some things that were missing from there that should have been there, I think. I won't say any more than that at the moment. But some of that's proven useful. They printed about 200 pages of the information that I asked for. Some of it was held back. Some of it was not in the file because it was sitting in the Attorney General's office in Austin, awaiting his approval or disapproval, and he disapproved. So he wouldn't let me have about 38 pages, I think it was. I don't remember exactly. I filed one with the sheriff's office. I got a skimpy little 8-page thing, and it took 2 requests to get that much. I had 6 pages, I think, originally, and I ended up with 8 finally. Most of it was boilerplate. There was really no useful information there at all, and there was so much missing that should have been there that that's going to be useful for me in the book. It does prove that the case was poorly investigated. Actually not investigated really at all. But CASA, I filed an Information Request Act with them and followed that up with another one about a month after that. And I was able to get enough vital information about Connie Wilcox and her tenure there. I won't say exactly what it is because the writ has not been filed yet. And if there's going to be another trial, I probably shouldn't say more than that. But she lied by omission in order to get on my brother's jury. And this was a jury that traded votes in order to get a verdict, and that may help.